All right, so if you have been following the lawsuit that the American Federation of Teachers brought against the Department of Education, there's some new information that was released on the 17th of October, so just yesterday. So if you have not, or you don't know how to access this information, basically what you can do is just go into Google, type in American Federation of Teachers, first the Department of Education, and it will get you directly to this complaint here. So the complaint was initiated on the 18th of March, and if you've been following me, then I've went over this lawsuit quite a few times, beginning from when the initial complaint started, the amended complaint, all of that, the status reports. But for yourself, you can go directly here and you're able to look at all of the case information, so that way you can get an understanding for yourself. But I'm going to go all the way down to the joint status report, since I said this was just released yesterday. And if you are a federal student loan borrower, you want to read this lawsuit because a lot of things have come about with processes to get the Department of Education to start moving and getting some things done. This status report basically is what it's about is the Department of Education and the American Federation of Teachers. They've come to an agreement basically, and if the courts or if the judge approves it, then these are the things that they are asking for them to do. Okay, so this is what we're going to read over. So right here where it says number 54, October 17th, just hit download PDF and you'll be able to get direct access to the information. All right. Okay, so this is where it gets started at. And if you go back and read the amended complaint, the certification that they had to become a class, all of those things, it'll all make sense to you, okay? Or go back and watch some of my videos. I break this down for you. But it tells us it starts with the parties has conferred. So basically, they've had a discussion, provide the following joint status reports, resolve the pending motion. They tell you for preliminary injunction, and motion for class certification without the need for intervention from the court. The parties have agreed to the following subject to the court's approval. So it tells us the party respectfully asks the court to deny without prejudice the plaintiff's motions for preliminary injunction. They ask the court to deny without prejudice, meaning that they can come back and try this all again. The plaintiff's motion for class certification. They respectfully ask the court to stay defendant's deadline to answer or otherwise respond to the first amended complaint and all other applicable deadlines pending further order of the court. Defendants will continue processing loan cancellation. This is where we start getting to the part for student loan borrowers. If you're like, okay, I don't know what 1 through 3 is, but this is where it gets into the information for you as a student loan borrower and other the parties that are a part of this case. Okay. So defendants will continue processing. When we talk about the defendants, we're talking about the Department of Education. So they are the defendant, of course, in this complaint. So defendants will continue processing loan cancellation for borrowers who are eligible for cancellation under the income-based repayment plan. Now, we know right now, with everything that is happening with the government shutdown, things are just been slow in general, okay? So I'm thinking that with this agreement here, the American Federation of Teachers, what they want to do is let's get something going. We know that things are shut down, processes have been moving really slow, but we still need to get some moving. We still have student loan borrowers who are currently still affected greatly by them not getting things processed and things not moving along. So I believe this is why this is all taking place and why they're like, okay, look, let's get something moving. But it says defendants will not deny as ineligible any borrowers applying for IBR plan on the ground that borrowers lacks a partial financial hardship as previously defined, and they give you the code that's under the Higher Education Act. There's a lot of federal student loan borrowers who were applying for income-based repayment. And the Department of Education, they removed, because with the passing of the One Big Beautiful Bill Act, they removed the requirement that you had to have a partial financial hardship in order to qualify for income-based repayment. Well, borrowers were going in trying to apply for income-based repayment and were being denied access to the plan, to the repayment plan, because of a partial financial hardship. So that was an issue that needed to be fixed. And this is where they're saying defendants will not, so the Department of Education will not deny as ineligible any borrower applying for the IBR plan on the grounds that the borrower lacks a partial financial hardship. They give you the section of the Higher Education Act. Defendants will hold such borrowers' applications in abeyance until defendants update their systems to allow for proper processing of these applications. So basically what they're asking them to do is when they hold these applications in abeyance is to basically don't deny them, so they don't necessarily have to deny them or approve them, just basically let them just chill out for a second until they get their system updated. Defendants affirm and will state on studentaid.gov that borrowers who apply for the IBR plan on or after July 4th, 2025, and were denied on the basis that they lack that partial financial hardship are invited to reapply. So if that is something that happened to you, you apply for income-based repayment after the 4th of July, What should be coming up on the student aid website once we get this court approval here, is that it'll state that if you were denied based on a partial financial hardship, that they're asking you to go ahead and reapply. Defendants will continue processing loan cancellation for borrowers who are eligible for cancellation under the original income contingent repayment and pay-as-you-earn plans as long as these plans are in effect. Defendants will continue processing applications for public service loan forgiveness buybacks. Defendants agree that for their internal purposes, the date a borrower becomes eligible to have their loans canceled under the IBR, original ICR, or pay plans constitutes the effective date of their loan discharge. Now, this is where they're going into, because what was happening, or what the concern is that when it comes to the processing of forgiveness for federal student loan borrowers, if these applications, for those who have already met the threshold, meaning you've met your the terms of your repayment plan, either at 20 or 25 years, if the Department of Education did not discharge that loan because there was the American Rescue Plan Act that was passed back in 2021, it was a temporary law that was put in place during COVID. But what it did was it allowed that, well, what it basically stated was that any student loans that were discharged after December 31st, 2020, but before January 1st, 2026, would not be considered as taxable at the federal level. So what was the concern is that with everything that is happening in the Department of Education not processing cancellation, not processing discharges, is that for those who get their loans discharged after January 1st, 2026, or after December 31st, 2025, they will be liable to pay taxes. It will be counted as income in the eyes of the IRS. So basically what this is saying is that the defendants agree for their internal purposes, the date a borrower becomes eligible to have their loans canceled under the IBR, ICR, or pay plans constitute the effective date of their loan discharge. So if you meet your 240 or your 300 qualifying payments, and you meet that, let's say you meet it December 25th, and they don't actually approve it until sometime in 2026, the date that you met that qualifying payment count, that's the date that's going to be considered as your eligible discharge date. So you will not be subjected to those the tax, they call it the tax bomb, if it was discharged technically over in 2026. Okay, so defendants, where we at? 8A. Defendants agree to not file an Internal Revenue Service Form 1099-C. The 1099-C is where it would count as income. So because they're canceling a debt. For a borrower who becomes eligible for discharge in 2025, if the conditions in the IRS Notice 2022-1 are met. For avoidance of doubt, so basically they want to make sure there's no confusion, there's no misunderstandings, the Department of Education agrees that for their internal purposes, when a borrower has achieved eligibility under the Saving on a Valuable Education Plan, applies to transfer to one of the IBR, so income-based repayment plans, original ICR pay plans, on or before December 31st, 2025, and the application is approved on or after January 1st, 2026, the day that the borrower becomes eligible for cancellation under the new plan constitutes the effective date of their loan discharge, even if that date falls on or before the date the borrower's application was approved. So more or less, if you are someone who, let's say you were in the SAVE plan, that's what they're saying, you transfer into income-based, pay as you earn, and you meet that timeline, meaning you meet those qualifying payments. As soon as you meet that qualifying payment, of course, as long as it's before that 2026 date, January 1st, then you won't be subjected to taxes. It won't be considered as income if it's discharged later into 2026. Okay. All right. Pursuant to the above, defendants confirm that any borrowers who qualifies to have their loans discharged through an income-driven repayment plan, which includes IBR, original ICR, and pay, will continue to be reimbursed for any payments made on the loan after the final payment that qualified them for discharge. So if you're someone that's still making payments, and we have a lot of borrowers who are, you've already met the threshold, but because everything has just been chaotic, you're still making payments. Once you have met the 240 or those 300 qualifying payments, then anything additional you will be reimbursed for. Plaintiffs acknowledge that the IRS and the U.S. Department of Treasury and not defendants have the final say on whether defendants' student loan cancellations qualifies as taxable income. So basically what they're saying is that the American Federation of Teachers, they are aware that the IRS and the Department of Treasury are the ones who have the final say about the student loan cancellation qualifying as taxable income. Defendants will file 6 status reports. So the Department of Education will file 6 status reports, and this is what those reports will provide. Public information about certain topics raised in this litigation. Defendant's first status report shall be due 30 days after the current lapse in federal government appropriations ends, and subsequent status reports will be due every 30 days thereafter. After the filing of the 6th status report, the parties will confer about the need for further reporting, and if necessary, will inform the court of their positions on whether further reporting is necessary. So we know we at least have about 6 status reports that will be coming, and basically what those reports will do is provide more information about PSLF buyback, where they are with the processing of income general payment plan applications, things of that nature. And if you go back to court listener, you can look at some status reports and you'll see where the Department of Education is as far as with getting applications processed and also buyback requests. Each status report will include the following information about the last full calendar month preceding the date of the report. And we know that these status reports, they are due usually on the 15th of the month, and they will provide information about October 1st to October 30th. So it will say the number of IDR plan applications that were received during the preceding month, the number of IDR plan applications that were pending at the end of the preceding month, the number of IDR plan applications that were decided during the preceding month, if possible. That number should be broken down by whether the application was approved or denied. And this is extremely important. We need to know when they're talking about applications that were processed, does that mean they were approved or denied? So I'm excited to see what this says. The number of borrowers whose loans were discharged under an IDR during the preceding month, if possible, that number should be broken down by whether the discharge was pursuant to IBR, ICR, or pay plans. Another one I'm definitely interested to see. The number of PSLF buyback applications that were received during the preceding month, the PSLF applications that were pending at the end of the preceding month, the number of PSLF applications that were decided. That is for which defendants have completed processing during the preceding months, broken down by the number that were approved versus denied. The number of borrowers whose loans were discharged under PSLF during the preceding month. In the Department's Education's first status report, they will explain the method that they use to identify borrowers whose loans are eligible for discharge through the IDR plans. The first status report, they will also provide the number of borrowers whose applications for the IBR plan were denied on or after July 4th on the ground of the borrower lacked the partial financial hardship. And they go into by agreeing to the foregoing. Defendants do not stipulate to or concede any factual or legal allegations that have been raised or could have been raised in a proceeding, including but not limited to any findings. The court will be required to make granting injunctive relief. The parties respectfully request that the foregoing agreement be adopted by order of the court. Then it gives you all the information about the attorneys and everyone that's involved. So I'm excited to see what comes with all of this information. I'm actually happy to see that the Department of Education has agreed to do some things, especially as far as what borrowers whose loans who qualify currently for their loans to be discharged will happen to them on the federal level with that tax situation. So I'm actually excited to see what all comes about, and I'm hoping that this gets approved sooner than later. And then we'll just keep following it and see what happens next. But like I said, you just go to Court Listener, or just go to Google, type in American Federation of Teachers versus the Department of Education, and you'll be able to get all of the information. All right, we'll stay tuned and we'll see what's next.